go ahead and get us started without too much ceremony. But I'm Nina Polano, one of the co-hosts of Sidebar, a podcast from Courthouse News. And I'm joined today by co-host Nicholas Jovino, who's also on the podcast, and then Courthouse News reporter Kelsey Reichman. We're going to talk about a few Supreme Court issues today, but before we get into, I think, some of the big cases that we talked about on our most recent episode, Kelsey was present today, tuned in today to the Supreme Court arguments on the Texas abortion case that has a lot of legal scholars and a lot of people, frankly, talking about the future of abortion laws in this country. So let's focus on that first. The Supreme Court arguments lasted for about 3 hours, so I'm going to ask Kelsey to give us as much as she can as far as a recap and an overview. But first, just some background on the abortion case. This concerns the so-called heartbeat bill, Senate Bill 8 in Texas, which went into effect at the beginning of September and has been really fiercely fought by reproductive choice advocates since then. So I'll turn it over to Kelsey. There were actually two cases before the court today. Those are Whole Woman's Health v. Jackson and United States v. Texas. So feel free to talk separately or together about those cases. But if you could just start, give us a little bit of background on this piece of legislation from Texas. And if you're just joining, we're talking about SB 8, Texas's so-called heartbeat bill.
Hey, yeah. So like you said, there's two cases currently being heard by the court, and they're challenging the same bill, SB 8, which bans all abortions after cardiac activity is detected. And so this ban went into effect on September 1st, and if you'll remember, it was at the court before. In that case was the Whole Women's Health v. Jackson case. So that case went to the court before. The court did not block it from going into effect. So the law went into effect. And since then, there's been cases challenging the law. Whole Women's Health v. Jackson continued, and then United States v. Texas started as well because of... it's really all about this enforcement issue, because SB 8 is not enforced by state officials. It's enforced by private citizens, which has created these very weird procedural issues that have been really hard to overcome for challengers to the law. And, for pro-life activists and advocates, they've been stymied before by pre-enforcement challenges, and this case has been really a change to that, where they have been able to block the law without a pre-enforcement challenge, or sorry, getting a little confused there. But so the cases the court heard today, they didn't hear issues on the merits of the case. These are really procedural issues, and the procedural issues are tied to that enforcement mechanism that the case uses. And so when they heard the challenges, while all of this concerns abortion and abortion rights and women's reproductive health, none of the arguments today were about that. They were all about this pre-enforcement challenge and how the law is enforced. And what's interesting about that is there are some advocates, such as a gun rights group, that have filed amicus briefs in the case saying that if this case can be enforced for abortion, it can be enforced for any other constitutional right, whether it be Second Amendment, First Amendment. Any state could take whatever their issue is that they would like to either, if they want to get rid of Second Amendment rights, they could make that happen, or, the other way around. The arguments this morning were obviously highly anticipated, and one of, I think, kind of a top line takeaway were in the Whole Women's Health v. Jackson case, there was a lot of skepticism from the justices, and in particular Kavanaugh and Barrett, who are kind of seen as, more of the consequential votes because of their, they haven't really stuck out a side on if they're going to be on the more conservative side or if there'll be more swing votes. So they seemed very, they seemed to challenge Texas's arguments in the case during the oral arguments this morning, and question how that would how those arguments would apply to other constitutional rights, and they seem to have issues with that. And let's see. Sorry, there was a lot.
That's great. No, that's great. And I'll ask you to talk a little bit more about what we heard from the justices too. But just for those tuning in, we are talking about some of the big items on the Supreme Court docket this fall. But starting off right now with Kelsey Reichman, who tuned into today's oral arguments in the Supreme Court concerning Texas's so-called heartbeat bill, the ban that limits abortions, basically bans abortions after 6 weeks. I want to just check in with Nicholas Iovino to see if there's anything that you wanted to ask about what happened today. Anything from you?
Yes. So Kelsey was just talking about how this arguments were made that if a state like Texas can pass a law with this unique enforcement mechanism that kind of restricts what is considered a constitutional right that has Supreme Court precedent behind it, that that any state could do that. But I was curious what Texas's arguments were as to why this law should be allowed to stay in place while the case continues.
They're really they pushed over and over again, the Solicitor General Jude Stone, that this is an issue that if everyone has a problem with it, Congress should be the one to answer that, and Congress should be the one to make a rule whether constitutional rights should or I guess if this right should be able. Sorry, gathering my thoughts. He said that Congress should be the one to say if states can or cannot enforce this right, I guess. So that was very interesting. I think an interesting comment from the justices was Kavanaugh kind of said, I don't know if Congress would be able to do that. And, it was a very interesting kind of line of questioning. I don't think he really, in the Texas case, they they kind of stuck to their guns where they said, we think that this, this enforcement mechanism is the right way to go about it. And, even when questioned on how it would apply to other constitutional rights, such as, gun rights, Kavanaugh explicitly said, what if someone was selling AR-15s? Could a private citizen sue them for $1 million? And Stone kind of stuck to his guns and said, yes, that could be something that happened, and we are not going to change our approach because of what right is being challenged.
So so this line of questioning that you mentioned, I did just want to ask, and I know we're talking about hours of arguments, so that it can be hard to kind of wrap your brain around. But were there moments, or any points in the judge's reaction, the justices' reactions, or in the arguments that really other points, I guess, that stood out to you besides what you've already talked about that you think could be influential in ultimately in the decision? I know we won't know what's going to happen for some months.
Yeah, so so that is actually interesting. So because this case has been fast-tracked, the attorneys in the case on the abortion provider side, they're looking for a really fast judgment just because of the consequences of the law. They say that the ban has, because it has effectively nullified Roe in the state. They want an answer as soon as possible. No one's really willing to read the tea leaves to how fast the court can rule. But because the case was fast tracked, they agreed to hear it, I think, like 10 days ago. So who knows what that will mean for a decision in the case. I did think it was interesting, the justices, while they were very willing to, lean into some of the arguments that the abortion providers made in Whole Women's Health, on the other side in the United States v. Texas, they were very cautious about the power and the authority that would give the government to intervene. And so you could see, and some of the justices asked questions on whether, if we rule a certain way in Whole Women's Health, what will that mean for the Department of Justice's case, and will they still have a case? Because the Department of Justice is really, their case is saying that no one else was able to challenge this, so we had to step in. So if the court allows the Whole Women's Health case to go forward, what does that say about the government's case? So it'll be interesting to see how they rule. And I would definitely say they leaned into the arguments on Whole Women's Health a lot more than the government's case, but we'll see. I also think it's interesting, there was a lot of talk about Jonathan Mitchell, who was really the architect of this enforcement mechanism. And, he argued in front of the court today, and there was a lot of talk about, what that could mean if the justices were going to question him, what kind of questions they would have for him. And honestly, it was kind of underwhelming, the questions they had for him. And I don't know if that was just because his argument came at the tail end of this very long session, or, if that said something about, the enforcement mechanism as a whole. Who really knows until they rule in the case. But it was interesting because it was something that I know a lot of people were looking forward to hearing.
Right, bit of a twist. As you're talking, and I'll just quickly, for those just joining, we are talking right now about oral arguments today in the Texas abortion case in front of the Supreme Court. As Kelsey was just saying, this is a very procedural case, or set of cases, pair of cases, and I think it's an interesting distinction from the Mississippi abortion case that's going to be heard on December 1st, where the focus, as Kelsey just said, the word abortion and the topic of abortion was not the focus of today. It was all about the procedure and enforcement of this law. Whereas what kind of hangs in the balance for the Mississippi case is Roe v. Wade, is the current legal precedent since 1973 that has guaranteed the constitutional right to an abortion pre-viability, is what's actually being challenged. And we talked about this on our most recent podcast, but we can recap it a little bit today as we get into some of the other big items on the docket. I think that what's interesting in that case is that, and this goes with some of what Kelsey was saying as well, if the court overturns Roe v. Wade in the Mississippi abortion case, it doesn't mean that all of a sudden abortion is illegal and it's everywhere in the country, but it means it's no longer constitutionally protected, and therefore goes back to the states. And a lot of states like Texas, like Mississippi, have these laws they're already trying to push through, or they have laws on the books just kind of waiting for that moment, called trigger bans, that will basically go into effect if the court overturns Roe v. Wade. It's possible in that case. So that case deals with a 15-week abortion ban in Mississippi. The Texas case is just 6 weeks. The state could win in the Mississippi case and doesn't mean that Roe v. Wade is overturned. Perhaps the Supreme Court could shift the parameters for what pre-viability means, maybe scale it down to 14 weeks or 12 weeks or so, and change that without overturning Roe v. Wade. But they're both really significant cases dealing with abortion, and I think really kind of speak to just what a pivotal and important moment this is in the court. I want to turn it over again, since I've talked for a while, to Nick. If you want to either talk about anything that we mentioned in the podcast that's kind of come to mind as we're having this conversation, or if you have more questions for Kelsey about today, giving you the floor.
Thanks, Nina. I did have one more question for Kelsey, because I understand there was a kind of questions raised about the relief that the plaintiffs are seeking in these cases over the Texas abortion ban. And there was even questions over who they would sue, because usually you sue the person who's going to enforce the law. In this case, they're saying private individuals need to enforce it. And Kelsey can correct me if I'm wrong, but I think they sued either the clerks or the judges in Texas. And I understand that there was some argument about, that the courts can't just say overturn or suspend a law. They have to direct an individual or an entity to not enforce it, or for the courts to do something. So I was hoping she could explain that.
Yeah. So first, I do want to comment on what Nina was saying, just as far as the Mississippi case, and while this case is not being considered on the merits, something that's stressed by a lot of the pro-choice advocates in the case and the abortion providers also stress this, that the court doesn't have to explicitly nullify Roe and Casey precedents for them to be basically effectively nullified. And so that's something that people are watching very closely on, exactly what the court says in both of these cases. And, back to the questions on who's being sued in this case. So what's really interesting is, and you're correct, it is the clerks and the judges who were sued in the Whole Women's Health case. And so it goes back to that enforcement mechanism that's really created all these procedural hurdles, which was intentional, because you don't get to the constitution, you don't get to the merits of the case because you have to deal with all these other procedural matters. And so in Whole Women's Health, the clerks and judges are the ones being sued. And something that was, a big topic of conversation between the justices was the precedent of Ex parte Young. And, for those of us who aren't experts on that, it basically says that state officials can be sued in federal court if they are trying to enforce unconstitutional laws. And so the abortion providers were saying that Ex parte Young supports an injunction against the clerks who they had sued to stop the ban. And, Kavanaugh really, dove into this topic, and he and I believe Justice Thomas as well, they were saying that Ex parte Young, actually, there's, I guess, 2 paragraphs in the ruling that exclude state courts. So it's an issue of the, what it's an issue of, what in theory the law should be and what's exactly in the text. So that's kind of, that's really the issue with Ex parte Young. And so they're really saying is, are these 2 paragraphs going to preclude the abortion providers from suing the clerks and judges? And the reason why they have to sue the clerks and judges, again, is just because of, if they sued one private citizen, one individual, it wouldn't exactly apply to everyone else. And Justice Barrett kind of touched on this, saying that, there would be, if one case went through and they, that case worked its way through the court, and you got a ruling in that case, it wouldn't necessarily apply to every other case. And so that's really the issue. And the abortion providers argued this as well, that, it would kind of create this avalanche of cases where there would just be so many cases that it would be very difficult to deal with.
Thanks, Kelsey. I guess we can move on now to some other big cases that are on the Supreme Court's docket this fall, including a case about gun rights. That's going to be argued in 2 days, on November 3rd. It's called New York State Rifle and Pistol Association v. Corlett. And it's about someone challenging New York State's basically this person applied for a concealed carry permit, and New York only grants those to people who can show that they have a special need for self-defense. And sorry, one moment.
I can jump in while Nick
Yes,
is gathering his.
please
Oh,
jump
yeah,
in.
yeah. No, of course. I mean, so we tag team this last segment. So Nicholas and I both have kind of like different. I think we did different interviews and talked to different folks. But I can say what I talked to somebody about this specific issue from the Heritage Foundation, and this centers on, as Nicholas was saying, New York's concealed carry permit application process. So in New York, doing more than just saying, I'd like to concealed carry. I'd like to carry a gun. Give me a permit. You have to present some kind of need, present some kind of proof that you have a reason to carry a weapon. And what that does to the to the obviously conservative leaning Heritage Foundation, their stance on this is that sort of overly burdens this right and makes the Second Amendment sort of a second tier constitutional right, whereas we think of things like freedom of speech as givens and as those kind of first tier. And so what their hope is that this comes down in favor of the people suing New York over its concealed carry permit process, and kind of validating that right, separating that from this application process that New York has put in place. Many states besides New York have rules about concealed carry and have applications, but this is the one that's kind of been a big talk, I think, about the Supreme Court docket this fall. And what you said that's November 3rd, right? Whoops, I think you.
Correct.
Yep.
And so yes, basically this decision has the potential to across the country that restrict concealed carry in states like California and many others. I did speak to one legal expert from Arizona State University, though, who said that states, even going back to before when they were colonies, have restricted the right to carry concealed weapons for centuries. And he said that's something the justices are going to have to consider. He said even before the Second Amendment existed, that states were doing this, and he says that some of the conservative justices might surprise some on the left by taking a more nuanced position and saying that that states do have a right to restrict the carrying of concealed firearms. However, on the issue of open carry, which is not before the court this term, but will be soon, will probably be soon, because the Ninth Circuit recently ruled that states can restrict the right to openly carry firearms in a Ninth Circuit case that came out of Hawaii. So Professor Werman, who I spoke with from Arizona State University, Elon Werman, he says he thinks the Supreme Court, with the conservative majority, what they could do is restrict or say that laws that are restricting open carry are unconstitutional, but perhaps allow states to continue restricting concealed carry. That's his prediction of what could happen.
Right. So we've talked, yeah, and we've I think pretty well covered the two abortion cases that are in front of the Supreme Court this fall. The one that was heard today in the Texas abortion law, and then Dobbs v. Jackson Women's Health Org concerning the Mississippi law, which bans nearly all abortions after 15 weeks. We have more on that in our latest episode, so make sure you follow us at Sidebar on Twitter. You can find us wherever you get your podcasts, but we do have a full episode on these topics. So today we're going to continue breaking them down and go through a few more cases, but please be sure to check us out, and you can hear the full episode and the full segment on these issues. I guess the next one that may be good to talk about are a few religious freedom cases. Nicholas, would you like to lead on that, or I could get into talking about the maybe starting with the Boston case. Do you want to break that one down?
Sure. The Boston case is about Boston refused this group's request to fly a Christian group's request to fly a flag at Boston City Hall that features a cross. And Boston has granted a lot of different groups the request to fly flags celebrating all kinds of things, including Juneteenth and Gay Pride. And this group says it was discrimination for Boston to refuse their request. But the legal experts we talked to, including UC Berkeley Dean Erwin Chemerinsky, says the real question is going to be is is this the city of Boston speaking, or is the city providing a public forum for speech? And if the city of Boston is speaking, then they have a right to endorse whatever messages they want. However, if they're providing a forum for public speech, they cannot discriminate. So that's the question that's going to be have to be answered in that case.
I think I had that one on my mind because you mentioned the colonies, and that's so the other religious freedom case that we discussed on the podcast, it has to do with school aid, and it comes out of Maine, where a group of families are suing for the way that for basically for being blocked to excuse me, the Maine school district distributes money to families who live in an area where they don't have their own public school so that they can attend the school that they choose, public or private. So the lawsuit, the money is not available for religious schools. So that's what the lawsuit focuses on. And that centers on these families saying they want to be able to receive this aid and be able to choose a religious school to send their children to. I don't have too much to add about this one. We do have some comments on it from experts on the podcast, but Nicholas, if you don't have anything to add, we can move along.
Well, I guess I would just say that one of the professors we spoke to about that, Elon Werman, said that he thinks some conservative justices like Samuel Alito and Clarence Thomas have made clear in prior opinions, including one from a few years ago about a Missouri state funding program that excluded a religious preschool, and they said that was not allowed. That he thinks the majority will likely continue with that thinking and say that Maine cannot exclude religious schools from this program, but we'll have to wait and see where that goes. As far as other big cases, the Supreme Court has already heard arguments on whether a Guantanamo Bay prisoner who says he was, has evidence that he was tortured overseas can testify in a deposition. They already heard arguments on whether or not to reinstate the death penalty for the Boston Marathon bomber. And there's another dispute that will determine if someone wrongly charged with a crime, this was in New York, they were charged with I think child sexual abuse, and they found out that it was just someone said they saw red marks on a baby's bottom, and it turned out to be diaper rash. But the person was uncooperative with police, and they pressed charges against them. And finally, the charges were dropped. But anyway, this will determine if you can sue for malicious prosecution after the charges are dropped. Looking ahead, on November 8th, the court will hear arguments in FBI v. Fazaga, which is about the FBI is accused of illegally spying on Muslims in Southern California. For an anti-terror investigation, they sent in an informant who illegally recorded them and went into their homes and gathered all kinds of information. It didn't lead to any charges. But the government says that this case needs to be dismissed because they say they weren't just targeting them because of their religion, but revealing the information that would help them defend themselves against this lawsuit would reveal sensitive national security information. So they're trying to use the state secrets privilege to block the lawsuit. We talked to the plaintiff's lawyer, Ahilan Arulanantham, who says if the government can run programs that violate constitutional rights and escape any judicial accountability, because the programs are running in secret, that it would open a profound loophole in the web of constitutional protections that apply in our system.
And we talk about this, I think, a good amount on the show, but all of these cases that we're talking about here have some strong political underpinnings and historically have really split people down party lines. So this is all happening in the backdrop, I guess, of this as being the first full term of this Supreme Court that has a conservative, a Republican supermajority, that 6-3 division. So we're about out of time here, but I just want to, again, encourage folks to check out the full episode. It's called Divided Court, Divided Nation. We talk about a lot of these cases, a little bit more. And then we also have a great segment on conspiracy theories and the story of Q from our colleagues at Sidebar. So definitely encourage you all to please follow us on Twitter. Please subscribe to the podcast Sidebar from Courthouse News. Again, I'm Nina Polano, co-host of the podcast, along with Nicholas Iovino, and joining us today was Kelsey Reichman, Courthouse News reporter in Washington. Thank you guys all so much for tuning in, and have a great week.